Hi everyone, thanks for watching Hamara Kanun. This week, in the next 10 minutes or so, we're going to discuss a very important question that comes up often. How do you register a trust? Now, for those who are new to the concept of trust, I'm sure most of you are not. The idea behind a trust, perhaps in the simplest language, is that a trust is created when there is a transfer of property from one person who is the owner to another person or a group of people who are called the trustees for the benefit of a third person or beneficiaries or the owner and another set of people. So once again, it's a transfer of property from person A to person or group of people B who are trustees for the benefit of another category of people. So the question that often comes up is, how do you register a trust? We have something called the Indian Trust Act. Also, different states in India have different trust acts. So when you're setting out to register your own trust, please make sure that you check out both the central level, which is the Indian Trust Act, but you also check out the relevant law in your state if there is one. Now, to the question specifically of, because that usually is the first question that comes to your mind if you have an intention to form a trust, as to how do you go about registering a trust. So this video is dedicated specifically to that question. Now, very importantly, at the outset, what is the difference between a trust and a society? That's a question that people usually confuse. There is some scope for confusion there. Legally speaking, a trust can be formed when you have a minimum of 2 people. That's fine. You can go ahead and register it. For a society, instead, society requires a minimum of 7 people to be registered. Secondly, kind of at a more technical level, in a trust, it's the trustees who overlook the property, who hold the property. In case of a society, it's usually a governing body that has more elaborate rules. Now, both trust and society are being considered as options when somebody's thinking of incorporating an organization for charitable or religious purposes. However, usually that's the case, but it doesn't have to be limited to that. And that brings me to my third point. So, okay, what's the difference between a private trust and a public trust, as those are the 2 major types of trust in India? If the purpose for which you're creating a trust is charitable or religious, or basically for the use of people who are public at large, then you would consider having a public trust, as opposed to a situation where you want a certain specific set of people or a specific set of beneficiaries, as we call them. If it is for their benefit that you're registering the trust, you would rather go for a private trust. Having understood that difference between a private trust and a public trust, the next question then is, okay, how do you go about creating a trust? Now, for that specific purposes, the Act, and I want to take you to some specific provisions of the Act. The Indian Trust Act 1882, Section 6 says that a trust is created when the author of the trust indicates with reasonable certainty by any words or acts. So please understand that it doesn't necessarily have to be a written document. What has to be clear with the reasonable certainty is that you want to form a trust. The section goes on to say that these are the following requirements for creating a valid trust in India, and there are 4 things. Primarily, an intention on the part of the person creating a trust to form a trust, a valid trust. Second is, you have to lay down what is the purpose for which you are creating the trust, the purpose of the trust. The third is, who is going to be the beneficiary in the trust. And fourth, what is the property, either movable or immovable, that the trust is going to hold for the purpose for which it is formed. Now, as to the question of who may create a trust, any person in India who is competent to contract can create a trust. That means, by definition, it's people who have attained majority, who are more than 18 years of age, you would think, can create trust. However, in India, there is a provision that even a minor can create a trust by obtaining the requisite permission from the civil courts of original jurisdiction. Who can be a trustee? Any person who has the right or who is capable of holding a property can be a trustee. If there are decisions where discretion of trustee would be required, then the person should also have the competence to contract, not just to hold a property, to be a trustee. How do you register a public trust? So within 3 months from the date on which you have expressed your intention, mostly people would do it through a written document. It is suggested that you do it through a written document, and you have a written document giving birth to a trust. Within 3 months of doing so, you have to report to what we call the registrar under the Indian Trust Act. Usually the collector in a city of a city is the registrar. Every working trustee has to report to the registrar. There is a certain application which is easily available that you can access either at the registrar's office or even online. You have to fill out that application, fill out the particulars and report to the collector. The collector will ask you, as per the application, what is the origin of your trust, what is the nature, and finally what is the object of the trust. So those are the three main things that the registrar will look at carefully. The registrar will also look at other things, and I want to take you through that certain list. So this is kind of a certain checklist that you can keep in mind when you're filling out the application or contemplating creating a trust. What will be your principal office of business, or where will the trust be situated? What are the names and addresses of the working trustees and the manager? Sometimes there's a distinction drawn between, so for example, if you're bringing in 10 different trustees, you will then have to appoint a manager. You will have to provide the contact details and residential addresses of all of those. What will be the mode of succession to the trustee? So what happens usually is when you're creating a trust, you try and limit the duration of it, mostly for 3 years. So the registrar would want to know that once that time elapses, when that period elapses, what will be the modus operandi for succeeding for the next set of trustees to come into picture. Most importantly, for the registrar would want to know, or would want to have rather, a list of movable and immovable trust property in the state, and the particulars thereof, which will basically be for the purposes of identification thereof. Also, the income that is being derived from the movable and immovable property or from any other source that the trust controls in one way or the other. Usually, the registrar every now and then will ask you to provide the income generated or the controlled by the trust, and it usually is for a period of the last 3 years. What is the amount of average annual expenditure that you will be making in connection with the trust is also an important factor. And finally, obviously, for purposes of practicalities, what will be the communication address or the place where the registrar can get in touch if he or she has any questions. There could be other particulars required depending on requirements in a certain state, but those are the broader factors that the registrar may require of you. So in this brief video, what we've tried to say is, if you're contemplating coming up with an organization which is for a religious or a charitable purpose, in which case it would be a public trust, or to benefit any specified set of beneficiaries, in which case it would be a private trust, your first question would be, how do you register a trust? As I said, you will have to look into the Indian Trust Act 1882, and you'll also have to look at if there is a relevant law in your state. The registration procedure is rather simple. You can, by words, spoken or written, come up and clearly indicate your intention, purpose, origin, beneficiaries, and the movable and immovable property that the trust will hold. Once you have all this in place, within 3 months of coming up with it, you need to, or at least every working trustee needs to report to the collector, provide an application, and provide the particulars thereof. It looks simple, and the idea is to make it sound like it is simple. Of course, you can take the help of lawyers, but registration of trust is something that you can carry out very much by your own self. I hope that you register a lot of public trust and do some good. Thank you so much for watching Hamara Kanun. I'll be back in next week with another video where we will discuss another relevant topic for you. Thank you so much for watching Hamara Kanun. Please share it on social media, Facebook, Twitter, WhatsApp, other social media platforms if you find this useful. Thank you so much for supporting the initiative.